are sold.
AM 560, The Answer.
Welcome back, Chicago. You're listening to the show all about small business, jobs, and entrepreneurship. You're listening to Get Down to Business. I'm your host, Shalom Klein. Check out my website, shalomklein.com. Follow me on Twitter at Shalom Klein. I've got a real treat for you. I am thrilled to be joined by attorney Brian Weinthal, who, Brian, you have become a bit of an expert on the topic of really why Illinois employers have to think twice about using biometrics for employee security. A fascinating topic. We're going to get right into it. But Brian, before we do, let's get to know you. Tell us a little bit about your practice and who you are.
Sure, of course. Well, thank you for having me, Shalom. I really appreciate it. I'm a partner currently with a law firm called Burke Warren. My primary area of expertise is employment law. That divides pretty evenly into your standard employment law cases for employers, like discrimination, retaliation, things like that, but also includes more novel topics that I'm sure will be interesting to your viewers, like BIPA, the Illinois Biometric Information Privacy Act. Prior to that, I had been a partner with an AmLaw 200 firm, a larger firm. Prior to that, with a smaller plaintiff's firm. And before that, I'm sure near and dear to your heart, I was a naval officer and judge advocate with the United States Navy.
Well, thank you for that. You picked the wrong branch, but other than that, I've got no criticism for you.
We'll agree to put aside our Army-Navy rivalry for now, Shalom. How about that?
Sounds like a plan. So, Brian, it's a fascinating topic in everything that you're doing, because right now employment law is certainly a fascinating area. Right now, there's so much going on, so many changes in employment. I mean, on this show alone, we talk to employers that are growing and increasing their headcount, as well as employers that are having to, unfortunately, furlough and lay people off. It's a tough situation. So BIPA is a really interesting acronym that many of our listeners might not be familiar with. It is the Illinois Biometric Privacy Act, which is certainly very relevant right now. So right now, businesses are starting to reopen at some level, whether it's a retail location or a service-based business. All companies are trying to eliminate touch points to avoid transmitting the virus. Tell us a little bit about how biometrics is something that's sort of a topic now, and why you are so passionate about making sure that employers do think twice before implementing biometrics for employee security.
It's a great question, Shalom. And to answer it, I want to give you a little bit of history. So BIPA was passed by the Illinois legislature in 2008. For a long time, more than a decade, we heard nothing about the statute. And the reason for that was, in order to allege a violation under it, those folks who felt they were aggrieved by it were required to allege some type of additional injury or harm. So, for example, when we talk about biometrics, what we really mean is fingerprints, voice prints, retinal scans, and any type of facial recognition technology. If that's taken from me, I can go to court and say, wait a minute, someone took that from me in violation of the law. But prior to last year, I had to allege something more. My identity was also stolen. I suffered some type of financial loss. They sold my information. What we found out last year is that in order to go to court, all a plaintiff has to allege in BIPA cases is that their biometric information was taken in violation of the law. If they can show that, if they can show what employers or other companies didn't do right, they can march right into court and ask for some statutory violations. And what we're seeing as the result is dozens of class action cases being filed each week under BIPA seeking to get those statutory damages.
Well, Brian, there's a lot of information that's being collected over there every time an employee enters and exits a building, certainly clocking in, clocking out, all sorts of ways that biometrics, I mean, to many listeners, it's the coolest thing. It's so convenient, aside for the health risks. But you're saying that BIPA is really something that employers that want to watch their liability should be very careful of. And Brian, to be clear, other states have passed legislation as well. I believe Texas, Washington states have passed different things. But what makes Illinois unique and different from the other legislation in other states?
Illinois, Shalom, is the only state right now that allows a private cause of action by someone who believes they've been aggrieved by the statute. In other words, while other states are regulating the collection, They don't give individuals like you and I the right to walk into a court to claim that they've been injured in some way. Illinois is still the only state that allows that for regular everyday folks. Interesting that you mentioned before the idea of clocking in and clocking out. The big debate that we have under BIPA right now is, what is a violation? The statute says that as an individual, I can claim my rights have been violated when someone takes my biometrics without asking. From my perspective, as a traditional management side guy, I would say that once a fingerprint is collected by an employer upon someone's clocking in, that information is collected and the violation is done. My colleagues in the plaintiff's bar, of course, will tell you that every time an individual signs into work, every time they walk up to the scanner and put their fingerprint on it to clock in or clock out is a violation, multiplied by the number of employees, multiplied by the years over which the company has been doing that, you get yourself to several $1 million in a demand quite quickly in that setting. And there still is yet no court decision that tells us exactly what a violation is.
So I'm chatting with attorney Brian Weinthal from the firm of Burke, Warren, McKay, and Saratella. I hope I got that right.
You did.
And Brian is primarily an employment attorney, but really, really fascinating because you really touched on an interesting aspect of the law over here that many of our listeners don't know a thing or two about. And I guess the lesson over here is don't jump at the latest and greatest technology because you could potentially be on the hook for millions and millions of dollars. Brian, I've got to squeeze in a quick break. Can you join me in just a moment when we return? We'll talk more about your practice and other things that employers all throughout the state of Illinois need to be conscious of. You're listening to Get Down to Business, the show all about small business, jobs, and entrepreneurship. Check out my website, shalomklein.com. We'll be back with attorney Brian Weinthal when we return in just a moment.
Imagine if your most the answer.
Back on Get Down to Business, the show all about small business, jobs, and entrepreneurship. And I'm thrilled to be rejoined by Brian Weinthal, who is a litigator who currently represents a wide variety of companies in commercial and work-related disputes. Lots of experience trying cases as a first-chair lawyer before both judges and juries, but also a trained advocate who routinely represents clients on a broad range of alternative dispute resolution. Brian, you have a wealth of knowledge and experience, and we are living in unprecedented times in this world of COVID. All businesses in Illinois and beyond going through lots of changes. Brian, what are you hearing from your clients?
You know, Shalom, as you read some of my background there, I couldn't help but think how much that's changed over the past, let's call it 8 to 12 weeks. COVID-19 has radically changed for all business owners what they actually need to be doing in order to both protect themselves and their employees and customers in this climate. I have to tell you that much of my work has shifted to focusing on things like the FFCRA, the new statute that's been passed in order to give employees both paid sick leave and potentially paid family medical leave over that period of time. I've also done a tremendous amount of advising now when it comes to unemployment claims, which is a big issue for all employers who are being required to furlough and conduct layoffs during this period of time. But almost more prominently than anything else, I have been discussing with businesses the idea of liability waivers. As businesses in Illinois seek to reopen, there is almost no question that they should decide whether or not it's appropriate to have some type of liability waiver in place so that the customers and visitors who come to their workplaces can't turn around and allege theories of recovery if they become ill with COVID-19. I'm sure you've seen, Shalom, that throughout the media, there have been every imaginable manner of litigation and lawsuit filed to see if folks can test the relationships to figure out if they can drive recovery. Walmart, for example, is being sued as we speak under the theory that they knew that certain employees were COVID-19 positive, didn't tell others, and should now be liable when folks got sick. It's an interesting mix. And as I'm telling any business owners, and as I would tell all your listeners as well, if you can put some type of liability and waiver in place for your customers as you get started again, it is worth doing in an effort to limit your potential liability on the other side.
Brian, I have to ask, I go for a walk every morning, a long walk. I pass by a number of businesses. I love seeing, local small businesses, and almost without exception, every single retail storefront has a sign on the door. You must wear a mask. And often they say you must do this, you must sanitize, you must do this, you must do that. Is that notification alone enough to cover themselves to protect themselves from any liability?
Like any good lawyer, Shalom, I'll tell you the answer is it depends. The upshot is that businesses can take various steps in order to protect themselves. I think for purposes of reducing liability, it's a great step and in the right direction. And I have to tell you candidly that while the world seems to be melting down around us with regard to the debate over wearing masks or not, most of my clients and just about all the businesses you're seeing, I think, are taking the responsible step to ask folks to please wear masks when they come into the spaces. So I don't think the debate is as broad or as widespread as we're led to believe. It's a wonderful step for employers. What truly will protect them is some type of written information, delivery of a waiver, in order to confirm that customers are aware that they inherit some type of risk simply by walking in or patronizing the business.
That's
I should
great
also
advice,
mention,
Brian. We're running out of time. So Brian Weinthal, you picked the wrong branch of the military, but you do know a thing or two about BIPA, the really, really fascinating topic of biometrics and the liability that employers are potentially putting on themselves just by embracing some new technology. And we talked about COVID and that liability protection as well. Brian, I want to make sure our listeners know where they can reach you. Can you share your website and contact information?
Absolutely. You can find me at burklaw.com, and I'm an extremely active LinkedIn user as well. So all you have to do is hit my name, Brian with an I, and then Weinthal, Weinthal, and you'll find me at LinkedIn. Again, I would encourage anybody that's going through issues here in the wake of COVID-19, please reach out to me.
Thanks for joining us, Brian. Success. Let's get down to business. We'll talk to you next Sunday at 6 p.m. right here on AM 560 The Answer.
Did you miss the opening